Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me now is Forbes senior contributor Adam Minsky. Adam, thank you so much for joining me.
Thanks for having me, Brittany.
As you know, the Supreme Court began hearing oral arguments over President Biden's sweeping student loan forgiveness plan. What do we need to know?
Well, so the oral arguments were yesterday. They were pretty intense. And ultimately, I think it's anyone's guess as to how this ultimately ends here. A majority on the court did seem to express varying degrees of skepticism about the Biden administration's authority to enact this type of student loan forgiveness initiative. That being said, there also was significant discussion on the issue of standing, whether the parties that brought the suit are able to demonstrate an injury sufficiently connected to the program that would allow them to contest it. And that issue could potentially be really critical to whether the program is ultimately upheld or not.
Before we get into the nitty gritty here, there are two challenges. Can you describe them both for us?
So there are two challenges. One is brought by a coalition of Republican-led states, which are arguing that the administration's program will deprive the states of revenue because it will effectively encourage borrowers who have federal loans issued through an older program called the Family Federal Education Loan Program, or FELP for short, which are older loans that are issued by private entities and guaranteed by state-affiliated nonprofit agencies. Their argument is that it will encourage borrowers with those types of loans to consolidate those loans into the government's direct lending program. They argue that that will harm financially FELP agencies, which in turn will harm the states because of the states' relationships with those state agencies. The key agency here for this particular case is MOHELA, based in Missouri. The second case involves two borrowers who claim that they don't benefit enough or fully from the program as it was drafted. One borrower would be eligible for $10,000 in loan forgiveness rather than $20,000, which is the maximum amount, and the other borrower wouldn't be eligible for any loan forgiveness under the eligibility rules. They argue through their organization that's representing them that the way this program was established under emergency regulations prevented them from being able to participate in a public comment period, and they're arguing that that was harmful and that renders the program illegal.
Adam, you're an attorney who specializes in student loan law. Out of these two cases, is there one that you think has a better shot of winning opposed to the other?
Even before the court hearing, I think there was general agreement that the case brought by the coalition of Republican-led states centering on MOHELA was the stronger of the two. Following yesterday's hearing, I tend to agree. I got the sense that the judges on the whole were a little bit more skeptical of the second case involving the two borrowers as compared to the coalition of GOP states.
You said the judges sounded skeptical at some points during yesterday's hearing. Let's get a pulse check here. Where do you think each Supreme Court justice is leaning here?
So I kind of broke up the nine justices into three camps, roughly. There were definitely three justices who expressed the most hostility to the program in terms of how it was authorized and seemed least concerned about the issue of standing. That included Chief Justice John Roberts, Judge Samuel Alito, and Clarence Thomas. Then there were two justices, Gorsuch and Kavanaugh, who did seem uncomfortable with the legality of the program, but didn't express as much hostility as the other three justices. And they were a little bit harder to read on the issue of standing. And so it's unclear where they might fall on that. And then three justices, the three liberal justices, Jackson, Sotomayor, and Kagan seemed to be most favorably dispositioned to the underlying merits of the program and also were very hostile as to whether the parties had standing. And then Barrett, who didn't talk a whole lot about the underlying merits, seemed very skeptical that the challengers have standing to sue. So I would kind of group Barrett with the three liberal justices on the issue of standing. And then I think it's really going to come down to the two swing votes, Kavanaugh and Gorsuch, probably on the issue of standing as well.